Welcome to Daily Buzz News. NPA boss Shamila Batohi exposed. Advocate Ngcukaitobi's ruthless cross-examination uncovers alleged perjury in high-stakes inquiry. Our lead story today: NPA boss caught lying under oath. Advocate Tembeka Ngcukaitobi grills and tears apart Shamila Batohi's testimony. In the heart of South Africa's justice system, a seismic showdown exploded yesterday at the Nkabinde Inquiry. The National Director of Public Prosecutions, Shamila Batohi, found herself in the crosshairs, fighting for her credibility. Representing the suspended Gauteng NDPP Andrew Chauke, firebrand silk advocate Tembeka Ngcukaitobi SC launched a brutal, line-by-line cross-examination that left the NPA head reeling. With surgical precision, Ngcukaitobi accused Batohi of lying under oath, exposing glaring contradictions in her evidence, especially about a crucial advisory opinion from NPA consultant Dr. David Broughton on the scandalous withdrawal of charges against Richard Mdluli. The Nkabinde Inquiry was established by President Cyril Ramaphosa himself. Chaired by retired Judge Nkabinde, its sole mission: to decide whether suspended Gauteng NDPP advocate Andrew Chauke is still fit to hold office. But yesterday, the hunter became the hunted. Shamila Batohi, the very national director who pushed for this probe, suddenly found herself fighting for her own reputation under oath. Advocate Tembeka Ngcukaitobi SC came armed with documents, daggers drawn. He zeroed in on Batohi's evidence about the independent review conducted by NPA advisor Dr. David Broughton. Batohi had told the panel, under oath, that Broughton did not deal with the Mdluli matter at all and gave no opinion on it. Ngcukaitobi wasn't having it. He slammed Broughton's actual reports on the table. Twice in black and white, Broughton had dissected the scandalous 2011 decision to withdraw murder and corruption charges against former crime intelligence boss Richard Mdluli, charges linked to the 1999 killing of Ramajib. Broughton even wrote that the national director should consider hauling Chauke before an inquiry for that very decision. Yet Batohi knew the report. She had summarized it. Yet she told the panel those sections simply didn't exist. Ngcukaitobi didn't mince words. You deliberately gave a false summary. You lied under oath. The room went ice cold. Batohi fought back, claiming it was just a difference in interpretation. She insisted that when she said Broughton did not deal with it, she only meant he hadn't given a final recommendation, not that he ignored it completely. Ngcukaitobi fired back. The document says the exact opposite, advocate. How is that a difference in interpretation? Tension peaked. Even Judge Nkabinde intervened, acknowledging the clash was now about the meaning of words themselves, and that final judgment would come in closing arguments. But the damage was done. One thing is now crystal clear. The woman who sits at the very top of South Africa's prosecuting authority has been accused, in open forum and on live stream, of misleading an official presidential inquiry. And the nation is watching every second.
Now, can I then move on to another topic, just to understand these charges? My understanding of the way in which these terms of reference emanated is that you drafted them and the president endorsed your draft. Is that correct?
Well, actually, what happened is we went and checked this after. We did submit a draft to the president, but what the president adopted subsequently is quite different from the draft, and we didn't input into any draft that the president had. So there is a difference between the two.
All right. Well, I have not seen the draft you gave the president, and maybe you should send us that draft, because I understood all along that the president endorsed the draft that you gave to him.
No, that's not the case. We can let you have the draft.
Yes. Now, can I then go to making sure that I understand?
I beg your pardon. Advocate Batohi, what is the answer? You're saying...
If it has.
May we ascertain whether the draft document that was sent to the president as regards the terms of reference has been made available to the team? May I just verify with Advocate Mutlamunyani? Has it been made available to you?
Madam Chair, I'm not aware of any draft All what I'm aware of are the terms of reference that have been gazetted.
I still have one more question on the issue of this draft. Advocate Batohi, I want to confirm whether it is your testimony that the draft you gave to the president is different to the terms that the president finally signed.
That is correct.
Yes. And you cannot at this stage tell us what the differences are.
I can't.
Yes. All right. Can we then go to the terms of reference that the president endorsed? Because I am not under.
But Ngcukaitobi wasn't finished. He turned the blade again, this time on the very terms of reference that Batohi herself had drafted and sent to President Ramaphosa to trigger this inquiry. A bombshell issue. The racketeering charges against former KwaZulu-Natal Cato Manor Death Squad Commander Johan Booysen. Charges that were spectacularly struck off the roll because Andrew Chauke had acted completely outside his jurisdiction. Everyone knows that was the heart of the scandal. Yet when the official terms of Nkabinde Inquiry were drawn up, the document Batohi signed off on mysteriously made no mention whatsoever of Chauke, exceeding his authority, or acting ultra vires. Ngcukaitobi, voice like steel. Why is the most serious allegation against Advocate Chauke not even written in the terms of reference that you personally submitted to the president? The silence was deafening. Batohi shifted in her chair. Then, under oath, she conceded. I don't know why that precise phrase is missing. It might have been a mistake in drafting. A mistake. Ngcukaitobi pounced. So this entire inquiry, set up on your recommendation, is now being used to fix the holes that you and your team left in the original document? You are retrofitting the inquiry to plug your own oversights. Batohi refused to bite. Coolly, she replied there was simply a difference of opinion on how the terms should be read. But the message landed like a thunderclap. The woman who accused others of undermining the NPA had just admitted on a live broadcast that the foundation document of this multi-million rand presidential inquiry contained a glaring, unexplained omission, possibly a mistake from her own office. South Africans are asking tonight, if the national director can't even get the charges right on paper, how can we trust her to get them right in court?
One charge of defeating the ends of justice and the two charges of violating the Firearms Control Act.
As I said, racketeering by its very nature includes the predicate offenses. So it must include the predicate offenses as well.
Advocate Batohi, please answer my question. I am not asking you about racketeering offenses and its elements. I promise you I can read for myself. I'm asking you whether or not the independent charges of murder, the independent charges of defeating the ends of justice, and the independent charges of breaching the Firearms Control Act are included or excluded.
My answer to that is that it includes racketeering charges.
I know it includes racketeering charges because it says racketeering. I'm asking you if it excludes the charge of murder against Mr. Booysen.
It does not exclude it in the context of racketeering.
Advocate Batohi, I think we are going to be here for a long, long time if you don't answer the questions directly. We know racketeering, in order to establish, requires predicate offenses. That's not what I'm asking you. What I'm asking you is that Major General Booysen was charged independently of murder. Is it suggested in this charge that he should also not have been charged of murder independently of racketeering?
That's not what I'm saying. What I'm saying is that I can't, that's my answer, is that the predicate offenses are included in the racketeering charge. And so my understanding is that he would have been charged for those predicate offenses in the context of racketeering.
I honestly do not understand that. And let me give you a final chance. If you withdrew racketeering, Major General Booysen will still face a murder charge.
That's a different question, and I'll answer that now.
Yes,
so
now,
when I did withdraw the racketeering...
No, I'm not asking you to answer anything. I'm telling you the question that I'm going to ask you. Is 3.1.1 intended to suggest that Major General Booysen should not have faced the murder charge?
Not at all.
So you accept that he should have continued to face the murder charge or not?
Can I answer that question?
Yes.
After I decided to withdraw the racketeering charges, I sent all of the dockets back to the DPP KZN and asked her to consider each one of them and whether anyone should be charged with the predicate offenses outside of racketeering.
No, I still don't understand that. I'm asking you about the charge against Advocate Chauke. Whether or not you accept that there was sufficient evidence for Major General Booysen to be charged with the crime of murder or not? Or do you say there was also no sufficient evidence of the crime of murder?
On the basis of the decisions of the DPP KZN, after I sent the dockets there, she found that there was no evidence to justify murder charges against any one of the accused, except in the one docket. And that did not include Major General Booysen.
Yes, those are later decisions. I'm asking you about the decisions taken by Advocate Chauke. Is it the case of the NPA that Advocate Chauke erred in charging Major General Booysen with murder?
My understanding is that Major General Booysen was charged with racketeering and that those were the predicate offenses.
Yes.
And that is where we say Advocate Chauke erred in supporting racketeering charges.
To understand just how explosive yesterday was, you have to go back to two poison cases that still haunt the NPA. First, the Cato Manor Death Squad saga. Former Hawks boss Johan Booysen and his unit were hit with racketeering charges involving the deaths of 20 people. Andrew Chauke authorized the prosecution from Johannesburg, even though every single incident happened in KwaZulu-Natal. The charges were thrown out of court, the judge ruling Chauke had zero jurisdiction. Batohi's line has always been, Chauke acted recklessly and unlawfully. Ngcukaitobi fired back. There were 23 murder dockets that Chauke sent to the KZN DPP, but your own people never handed them over. Batohi was forced to admit, yes, those dockets went missing under her watch, but she still insisted the prosecution should never have happened. Then the Richard Mdluli murder file, the 1999 killing of Uparamajib, the man who married Mdluli's ex-girlfriend. Charges were withdrawn in 2011. Dr. David Broughton's review slammed that decision and expressly said the national director should consider an inquiry into Chauke for dropping the case. Yet Batohi swore under oath that Broughton never expressed a view on Mdluli. That single contradiction became the spear Ngcukaitobi drove straight through her testimony. But perhaps the most jaw-dropping revelation came earlier this week. Just 30 days after Shamila Batohi took office in February 2019, minutes show she held a secret meeting on the 6th of March. Present? Johan Booysen's lawyer, Carl van der Merwe, and senior counsel Anton Katz. Topic? Disciplinary steps against the very NPA prosecutors who had pursued Booysen. The families of the Cato Manor victims were never informed. Her own prosecutors were never consulted. She invited the accused legal team into the heart of the NPA to plot against her own staff. Ngcukaitobi, voice dripping with disbelief. You had just arrived, you hadn't read a single docket, and your very first move was to sit down with General Booysen's lawyers to discuss punishing your own people? South Africa is asking tonight, who exactly is Shamila Batohi protecting, and who is she willing to sacrifice to do it?
But we're certainly not suppressing anything.
Now, my instructions are that, in fact, there was a meeting with Mr. Epstein on the 6th of March, 2019, called by you at your office, which included the state attorney, Mr. Sabele Metza. Do you remember that?
I did have meetings with Mr. Epstein.
You did have meetings with him?
It may have, in fact, been more than one, because he had been dealing with a number of matters in the NPA. And so I just wanted an update on what was going on.
Yes, I'm asking you about one meeting, which is the 6th of March, 2019. Not asking you about other meetings.
All I'm saying is that I did meet with him, and that is possibly also a date on which I met with him.
Now, that meeting, I understand, was also attended by counsel for Major General Booysen, Advocate Anton Katz.
Oh.
Do you have any comment on that?
Unless my memory is failing me, I can't recall having a meeting with Booysen Katz and Epstein. But I'm not saying that it didn't happen. But I really, at this point, I can't remember that.
Well, it would have been a big story on your diary that you have called the advocate who represents the person who is suing the NPA into the same meeting with the advocate who's defending the NPA. I'm not understanding why you cannot remember such a big event?
Well, it may be a big event in your calendar, Advocate, but for me, I meet with lots of counsel, and I cannot recall whether they were both in the same meeting.
So your answer is, I don't remember.
That is correct. I do not remember.
Just like you don't remember if you got an opinion from him or not.
That is correct.
Yes. Now, I am also told that it was at that meeting that you instructed the state attorney to withdraw the opposition to the Major General Booysen application.
What date was that?
6th of March, 2019. I presume you also can't remember.
I can't.
Yes.
Ngcukaitobi saved his heaviest ammunition for last. He put the March 2019 minutes on the screen and asked the question burning across South Africa. How, Advocate Batohi? Do you sit in a meeting just 30 days into the job without reading a single docket, without speaking to a single implicated prosecutor, and declare that Andrew Chauke and others must face discipline for poor behavior? Batohi's defense? The atmosphere of state capture, the Zondo Commission public discourse. Ngcukaitobi cut her off. General Booysen only testified at Zondo in April and June, after your secret meeting with his lawyers. So which Zondo evidence were you relying on in March? Silence. Again and again she answered, I can't recall the exact source. He pressed harder. You invited Johan Booysen's attorney into the NPA. Let him hand over court papers attacking your own prosecutors. And you now say you can't even remember it? Batohi first claimed no memory, then quietly admitted it happened. Layer by layer, Ngcukaitobi exposed a pattern. Missing annexures in her own submission's critical facts left out of the terms of reference sent to the President racketeering authorizations overturned without her ever reading the actual dockets. The phrase state capture, repeatedly thrown at Chauke with zero personal knowledge. His final blow. Only the national director can authorize racketeering charges. You are the one person who cannot plead ignorance. Yet you never read the Booysen file before shredding decisions taken by your own prosecutors. That, Advocate Batohi, is irresponsible in the extreme. Even panel member Advocate Mathupa Ramakatsa voiced frustration at documents not disclosed in advance, another oversight blamed on Batohi's team. As the session ended in the Master of the High Court's office in Pretoria, one image lingered. The head of the National Prosecuting Authority, under oath, cornered, correcting herself, conceding mistakes, and repeatedly saying, I can't recall. Ngcukaitobi closed with a chilling warning. Labeling a senior prosecutor as a state capture enabler without evidence does not cleanse the NPA. It poisons it. South Africa watched live as Shamila Batohi's credibility took blow after blow. The Nkabinde Inquiry is no longer just examining Andrew Chauke. It is now examining whether the woman at the very top of our prosecuting authority is herself fit to hold office. This is the biggest crisis the NPA has faced in years, and it's only just begun.
I do.
Yes. Now, the definition of state capture as adopted by the Commission under Justice Zondo is a misuse of the state and its organs for private gain or for unlawful aims. Do you accept that definition?
Yes.
Do you have any personal knowledge that Advocate Chauke was involved in state capture?
I don't have any personal knowledge.
Yes, all right. So then it was grossly irresponsible of you to mention state capture in the context of Advocate Chauke when you have no personal knowledge of his involvement in state capture.
Should I comment on that?
If you want to, I'm putting it to you that I will argue that you were attempting to poison the atmosphere when you had no evidence, but you mentioned state capture together with Mr. Chauke.
The reason why I did is that I was asked about why I took certain actions when I did. And I explained that because that was in fact the NPA and capture of the criminal justice system was something that the Zondo Commission was inquiring into. And I couldn't turn a blind eye to the fact that that was what was being inquired into, and that as a responsible national director, in my view, I needed to consider all options. And the only reason why I mentioned it is because I was asked about the context and why I took certain actions. And that was what was also something that was on my mind at the time. So I considered all of this, and therefore I took certain actions.
Advocate Batohi, we are in an inquiry against Advocate Chauke. We are not in a state capture inquiry. My question was simple. You've given me an answer. You have no evidence that Advocate Chauke was involved in state capture. Yet you have repeatedly mentioned state capture in the context of this inquiry into Advocate Chauke. That is what I am saying to you is intentionally designed to poison the atmosphere of this inquiry, to create the impression that Mr. Chauke is involved in state capture, when you know full well that you have no such evidence.
I was asked what were the reasons for me doing certain things at the time. And I explained that that was the context within which I took those decisions.
Yes. Anything else to add?
When Ngcukaitobi put it to her directly, did the NPA ever genuinely believe there was evidence to charge Andrew Chauke with murder and racketeering? Batohi could only point to a single letter from the KwaZulu-Natal DPP saying no evidence, a letter written long after she had already suspended him. Again and again, the same picture emerged. Disciplinary charges against Chauke built on sand. Secondary reports, never the actual dockets. A misconduct case that rested almost entirely on one answering affidavit in the Booysen Review, and nothing more. In the Mdluli file, Dr. Broughton had twice written, in plain language, that Chauke's failure to prosecute the 1999 murder of Upa Ramajib was serious enough to warrant an inquiry. Batohi's sworn evidence? Broughton never dealt with it. When the paragraphs were read out in open session, her only shield was the word semantics. In the Cato Manor saga, 23 murder dockets that could have justified the racketeering indictment simply vanished inside the NPA, never handed to the KZN director, never seen by Batohi herself, yet still used as proof that Chauke had acted unlawfully. The threads all lead back to the same place. A secret meeting with Johan Booysen's lawyers, just 30 days into the job terms of reference, sent to the president that mysteriously omitted the most serious allegation a national director, who overturned major decisions and launched career-ending discipline without ever opening the case folders. As Advocate Ngcukaitobi put it in his final words yesterday, this is not cleansing the NPA of state capture rot. This is the national director using the machinery of the NPA to settle scores, to rewrite history, and to protect certain narratives, all while the real dockets gather dust. The Nkabinde Inquiry was meant to decide whether Andrew Chauke is fit to be a prosecutor. It has ended up doing something far bigger. It has put Shamila Batohi's own leadership on trial in the full glare of the nation. And South Africa now waits, breathless, for the verdict. Thanks for watching.